Today, I'd like to talk about a very recent order issued by members of the U.S. Supreme Court on COVID restrictions in California and how these restrictions implicate the free exercise of religious practice, which of course is part of the religious clauses, which of course fall under our First Amendment. But we see that our religious clauses are protected by the Equal Protection Clause as well. So we're going to talk about three of the restrictions that were at issue in this case, and then I am hoping to walk you through not so much the opinions, but where all of the different judges found themselves on the issue. And then I thought I could talk about the framework for the free exercise clause under our First Amendment and what other emerging issues that we can expect to see, not just in California, but nationwide on this issue. So before I begin, I just want to remind everyone that this was not the first time SCOTUS weighed in on restrictions as they apply to churches. In fact, back in November of 2020, November 25th, specifically, the court rejected restrictions on that affected religious service in New York State. Now there, the court issued what is called a per curiam opinion. So we didn't get an individual's name who sort of took ownership of the court's opinion, but we certainly saw different judges weighing in on the case. Now, part of what happened in that case is that it looks as if there may have been some remanding of some issues back down to lower court. So that was in New York. So the precedent had been set. We had already been aware that the court was willing to weigh into some of these restrictions, although the court has rejected weighing into other restrictions. So now I want to focus on February 5th, 2021's opinion in South Bay United Pentecostal Church versus Gavin Newsom, who's the governor of New York. I'm sorry, of California. So California had three restrictions that were at issue in this case. The first is a Tier 1 prohibition on indoor worship services. The second restriction is a Tier 1 capacity limit on indoor worship services. And here, the capacity limit was 25%. And then the third restriction at issue was one that banned singing and chanting during indoor worshiping services. Now, let me just pause to say that this third issue didn't look like it was one of the issues that the church and the plaintiffs had actually asked the court to decide, but the court decided to include a conversation, and I should say members of the court decided to include that conversation in this order. So with regards to the first restriction, this prohibition, this just general prohibition on indoor worshiping services, we only had 3 justices who voted in favor. And so that restriction was rejected. Justices Kagan, Breyer, and Sotomayor found that this was a sufficient exercise, or this restriction was sufficiently justified by the state of California. And for them, it would have been okay to continue to have this prohibition. However, Justices Thomas, the Chief Justice Roberts, as well as Alito, Gorsuch, Kavanaugh, and Barrett all agreed that this restriction went too far and it exceeded California's authority under its police powers. And so the court as a whole grants the order to reject the first restriction, which again is a restriction on Tier 1 communities from indoor services. The second restriction, this 25% capacity limit on indoor worshiping. We see that this was rejected by the court in this order along the same lines. Kagan, Breyer, and Sotomayor argued that this was sufficiently justified in that California was able to show a pretty compelling government interest, which is preventing the spread of COVID-19, and that there was sufficient evidence to show that this 25% capacity limit furthered that interest. However, the same judges rejected California's argument. Thomas, Roberts, Alito, Gorsuch, Kavanaugh, and Barrett all agreed that California had insufficiently shown that this restriction would likely reduce the effects of COVID-19, and so they rejected it. Interestingly enough, on this issue that no one asked the court to weigh in on, that would be the one restriction that is upheld. Of course, this is the third restriction, which includes restricting singing and chanting during indoor services. Only Thomas and Gorsuch rejected this restriction. And therefore, everyone else, which included Kagan, Breyer, Sotomayor, Roberts, Kavanaugh, Barrett, and Alito all agree that this was an okay restriction. However, let me make clear that Roberts, Barrett, Kavanaugh, and Alito have conditions on their approval of this restriction. And that condition is this: if it is shown, or if it can be shown, that California is not imposing this limit on indoor chanting and singing in a uniform manner, then the court will be willing to say, California, we're going to reject this restriction. Now, what should be understood is that none of these restrictions only apply to worship services. And so part of that caveat when it came down to this third restriction really had to do with how California was regulating the television and movie industry, i.e. Hollywood. There were many arguments that Hollywood was allowed to continue its productions with regards to chanting and singing. And of course, we can all see how singing and chanting is part of the production of visual content for movies, for television, web content, all of that. Interesting that the court did not really make any distinction, and it's unclear if California presented evidence that maybe TV and movie studios were wearing more masks, doing more social distancing than what you've seen in churches. Really no attempt by the court to get into the nuts and bolts of what is going on in these particular communities. It would seem to me that if anyone came back to say, hey, California's being uneven, even in its handling of these restrictions, then we will have to get into the nuts and bolts perhaps to see if California is really regulating more those who are just non-compliant versus just not regulating or only regulating one particular group, i.e. churches. Now, part of the reason why this last caveat is so important, I think, has to do with the state of our free exercise jurisprudence and our religious exemption jurisprudence as a whole, which is quite unsettled, as I argue in a recent publication with the UC Irvine Law Review, where I study religious child rearing and demonstrate how there are gaps, not just in our substantive due process jurisprudence when it comes to religious child rearing, but also in our free exercise clause religious exemption jurisprudence. And because of these gaps, we often find the court at quite a bit of tension, not just the court amongst the members themselves, as demonstrated in this California order, but the court is at issue with its prior jurisprudence. There's a lot of inconsistency, which I argue allows for different practices to exist that perhaps don't quite fall within what the court would consider one's free exercise of religion. So let me talk to you a little bit about this jurisprudence. And Hannah, I'm going to count on you to keep time for me a little bit, because I forgot to start my watch when I began my presentation. And so what we see with our free exercise clause jurisprudence is the court creating sort of two lines of thought in the analysis. One, the court focuses on whether or not any type of discrimination is what we would call facially discriminatory. versus something that is facially neutral. When it comes to facially discriminatory classifications, especially those that affect the free exercise of religion, the court has taken the stance that those type of restrictions or classifications receive the highest level of constitutional scrutiny, which we refer to as strict scrutiny. Now, strict scrutiny comes with a lot of advantages for a challenger. One, that law is already presumed unconstitutional. And two, it is the government that has the burden of proof to show constitutionality. Which means if the plaintiff wanted, they could choose not to put on any evidence about constitutionality and merely rest on the government's failure to meet its burden of proof. Now, it does not look like any of the restrictions here are facially discriminatory because these restrictions pretty much apply across the board. Now, in the court's opinion, it talks about its application to worship services, but a lot of that really just has to do with the plaintiffs are and their arguments, right? They wanted to engage in worship services, so that's where the court focused its attention. But these restrictions did not only apply in that context, hence the concern about how we're treating the movie, TV industry in Hollywood versus the plaintiffs at issue in this case. So again, if this were a situation where these were restrictions that only applied to churches, then clearly these would be facially discriminatory towards churches. It would receive the highest level of constitutional scrutiny. And I think it is very likely that the court would have strike down all of the restrictions, not just because of the impact on churches, but again, because if you're allowing others to engage in these activities, then why only restrict churches, right? But we don't have that type of situation here. Here, what we have are restrictions that we would call constitutionally neutral, in that they don't identify subject matter or topic, and they don't sort of single out a particular group or to some extent, there's some singling out of a particular type of activity. But again, I'll talk to you sort of merely restricting chanting. Well, it says nothing about the content of that chanting, right? So we wouldn't see that as targeting a certain type of message, or simply targeting, because chanting can be done by many different people, right? It's not only targeting church or religion. When it comes to these type of facially neutral laws, we have a rather complicated, well, maybe not so complicated, but we do have a rather controversial piece of jurisprudence that applies. This is an Employment Division of Oregon versus the Smith case. This was a situation where you had a Native American worker who wanted to engage in the use of peyote for medical purposes. They were fired, for religious purposes. They were fired from their employment, and they argued, hey, I should get a religious exemption in this case. You should not be able to fire me because I am following the dictates of my religion. Now, this line of jurisprudence had undergone a great deal of movement over the years by the court. In fact, prior to the Smith case, the court had said, well, these type of restrictions we think are just as bad as facially discriminatory ones. And so we're going to impose strict scrutiny, right? Anytime you interrupt the exercise of one's religion, government, you've got to deal with strict scrutiny. Now, let me just as an aside say there's some interesting history there. The court very often in the early stages of this jurisprudence, especially as it dealt with Sabbath days, the court rejected multiple claims by members of the Jewish faith. And then all of a sudden, the court gets a claim by a member of a Christian faith, and it finds, oh, wait, these Sabbath laws do violate the free exercise of religion. So some very interesting jurisprudence there. Some other very interesting jurisprudence there with regards to conscientious objecting to service in war. A very robust and interesting line of cases developed out of that. The court really came to the conclusion that you have to reject all war, not only certain types of war for there to be a free exercise clause claim. The other interesting development out of that jurisprudence is the court's decision that religion just doesn't mean sort of faiths, right? Organized faith. It really includes any belief that's sincerely held and occupies that place in your life that religion will occupy. So here, what we see is this idea that generally applicable laws, and this is the holding of Smith, generally applicable laws that apply across the board don't violate the free exercise clause merely because there's some effect on religion. Now, I would say there's some very recent jurisprudence that now puts Smith in doubt. One is our orders like these, where the court doesn't quite, and I should say very few members of the court really got into Smith, right? Is this the generally applicable criminal law such that we don't have to worry about free exercise clause claims? I think there is certainly a lot of commentary about the court's religious clause jurisprudence. Many scholars have been arguing that it's time to get rid of Smith, and they can sort of read the tea leaves, and they're assuming that there may be a majority of the court who's ready to abandon the generally applicable part of Smith. Many people argue that that's very dangerous because we very well could see the court selectively choosing which laws are generally applicable. And it is very likely that criminal drug laws would still interfere with the free exercise of religion, particularly the religious practices of Native Americans. And many are just pointing out how that sort of causes other problems, dealing with our Fourth Amendment Equal Protection Clause, race, and of course, all of the conversations we're having about Indigenous status, the founding of our country, and the type of respect that we probably have yet to show to our Indigenous communities. And so from my perspective, however, I think this is still, because of all of these gaps, because of the way the court in Employment Division versus Smith did not confront the race implications of its decisions, nor did the court confront any of the historical content or context for our Indigenous communities and the concerns that we have yet to address as a nation as it pertains to our original citizens. And so I think it is very likely that we'll continue to see the court struggle over this. One of the interesting aspects, of course, in this entire controversy, and this is getting back to the South Bay case, this order on February 5th, is Justice Kagan says, we're not scientists, right? Why are we second guessing the scientists here? And even Chief Justice Roberts kind of says, even though I'm saying we should not uphold some of these restrictions, I do want to remind America that I'm not a doctor, right? That I'm not a scientist. And so this debate that we're having about the place of science and how that coexists with religious belief, I think is alive and well in this opinion. And I think it continues to show the tension that we have when it comes to people who are not scientists making judgments in a pandemic that is very much based on science. And so what this means for future or other states and their restrictions, I would suspect after this order, many state COVID boards were going back to look at their restrictions to double check that they don't look like California's, because that means they're very vulnerable to attack. Another point I do want to make about this is that there was not a lot of conversation in this order by the court about some of the things that are unique to California. No acknowledgement that California has some of the highest COVID infection rates in the country, and how the difficulty of the largesse of California's population sort of hurts it. Even though many of these restrictions really did fall on the hardest hit of California populations, we see the court again not having any conversation that California was rather targeted, right? We're talking about restrictions, the first two in tier 2 counties. The court doesn't say, well, we think your tier system is garbage, right? And therefore, that's why we're ruling this way. The court really doesn't get into any of that. And so to the extent that California did try to, make different tiers, narrowly tailor their restrictions to the rate of COVID infections, it's very hard to see where the court acknowledges those efforts by California. Now, I say that because the court doesn't really give California or anybody any guidance in this order. It doesn't say, well, hey, California, we think you did okay here, right? To the extent that one of the restrictions on chanting and singing is upheld. The court doesn't really even, I think I should say Justice Roberts does say, well, there is some evidence that causes the spread of COVID, but no citation to what that evidence is, no citation whether it's a report, whether it's testimony or anything. And so the complete absence of the scientific conversation, I think, strikes me given the context that we're in, which is a medical scientific pandemic.